So, you're making a personal injury claim in Scotland, and probably the biggest question on your mind is this: am I going to have to go to court? It's a huge source of anxiety for so many people, so in this explainer, we're going to break down the whole process and show you what really happens.
Here's what we're going to cover. We'll start with that courtroom fear, then dive into the reality of just how few cases actually go that far. We'll look at how settlements actually work, when court becomes a necessary step, and finally, what a hearing or a proof, as it's called in Scotland, is really like, so you can feel more in control of the situation.
Okay, so first things first, let's just tackle that courtroom fear head on. The word court itself, yeah, it's enough to make anyone a bit nervous, and for pretty good reason. And really, this is the question at the heart of it all, isn't it? The thought of a court case can be so stressful that it might even make you wonder if it's worth pursuing your claim in the first place. We've all seen the TV dramas, right? The intense lawyers, the tough questions, the public gallery. So it's totally natural to worry about all that stuff, the formality, the scrutiny, the stress. But is that fear actually based in reality? Well, let's shift gears from that fear and look at the much calmer, much more reassuring statistical reality of how these things actually play out in Scotland. All right, here is the most important number in this entire explainer: 95%. That's right, an estimated 95% of personal injury claims in Scotland are sorted out without ever going to a final court hearing. That's a massive, overwhelming majority. And when you see it visually like this, the difference is just so stark. That tiny little sliver, just 5% of cases, go to a full hearing, what we call a proof in Scotland. The other huge chunk, that 95%, is settled through negotiation. Now, this doesn't just happen by accident. The whole system is kind of designed to make settlement the smart choice for everybody. For you, it means you get a clear outcome, you get it faster, and you can just move on with your life. For the defenders and their insurance companies, it's all about avoiding the huge costs and the complete unpredictability of a court battle. It just makes practical sense for everyone involved.
So if pretty much every case settles, what does that actually look like? Well, it's not just a random chat. It's actually a very structured process. Let's walk through the steps.
It all kicks off when your solicitor sends a detailed letter of claim. The insurer then comes back with an offer, which, let's be honest, is usually on the low side. And that's when the real negotiation begins. A bit of back and forth until hopefully you land on a final figure that everyone agrees on. It's a clear, logical path. Now, you might hear this word tender. All it is, really, is a formal, written settlement offer from the other side. But it's a really important one. Why? Because if you turn it down, and then later you go to court and end up winning less than they offered, well, you could be on the hook for their legal costs. And that's exactly why your solicitor's advice at this stage is absolutely critical.
But what about that 5%? Does going to court mean something went wrong? Not at all. Sometimes starting court proceedings isn't a failure. It's actually the right strategic move to get your claim moving forward.
You can kind of see the two paths here. On one side, you've got the signs that point to a straightforward settlement. It's clear who's at fault, your evidence is solid. But on the other hand, certain things can trigger court action. Maybe a legal deadline is getting close, or the other side is flat out denying responsibility, or you're just miles apart on what the claim is actually worth.
And this is maybe the single most important thing to get your head around in this whole process. Raising court proceedings, just filing the paperwork, is not the same thing as actually going to court for a trial. A lot of the time, it's just a tactical move to protect your claim, or to make the other side get serious about negotiating. Many cases settle soon after this step. Okay, but for that very small number of cases that do go all the way to a final hearing, or proof, what is that really like? Let's push aside the courtroom drama cliches and look at the reality.
You know, the reality of a proof is often way less intimidating than people imagine. It happens in front of a single judge, called a sheriff. There's no jury. Your legal team makes sure you are completely prepared to give your evidence. The whole thing is more of a calm, analytical process, not a dramatic confrontation. And honestly, most people who go through it say it was far less stressful than they thought it was going to be.
So, let's bring all of this together. The goal of this entire process isn't to force you down one road or another. It's to empower you, with the help of your solicitor, to make the best, most informed choice for your own situation.
If there is one thing to take away from all this, it's this right here. The personal injury system in Scotland is built to favor settlement. It's the norm, it's what's expected, and it's what happens in almost every single case.
That fear of a big, dramatic court battle, while totally understandable, just doesn't line up with what happens for 95% of claims. The system is designed for resolution, not for conflict. So the real question is, knowing this, what's your next informed step?